Court all rise. Hey. All persons having anything to do before the Honorable Justice of the Appeals Court, now sitting in Boston, far within the Commonwealth. Draw near, give attendance, and you shall be heard. God save the Commonwealth of Massachusetts. This court is now open. Please be seated. Good morning, Your Honor.
Good morning. All right, good morning, everyone, and welcome to today's sitting of the Appeals Court. I'll start by introducing the panel. To my right is Justice Greg Massing. To my left is Justice Robert Toone. My name is Ariane Vuono. I see a lot of familiar faces here, but I'll just review a couple of preliminaries. Each side has 15 minutes to present their argument. You can all be assured that we've reviewed everything that you have provided to us, and so in your time you may wish to go right to your most important points during your 15-minute allotment. No one is required to use all of their time if they do not wish to do so. I also want to remind everybody there is no rebuttal in the appeals court, so all of your points must be made when you first reach the podium. With that said, I'm going to call the first case, which is Commonwealth versus Dany, 2023-0143. And Counselor, please tell me if I've pronounced your client's name correctly.
Yes, SAKUNTHEAR Dany.
Dany, is that correct?
Yes.
Okay, thank you.
Good morning, Your Honors. May it please the court. May I proceed?
Yes, please do.
Long time no see from yesterday.
Yes, good to see you again.
Your Honors, I would like to start with my issue that I presented to the court, my supplemental brief regarding the recent holding of Commonwealth versus Due, 103 Mass Appellate Court 469, which was decided a few months ago. That case is very similar to the fact pattern in Mr. Dany's case, where there's an undercover police officer recording an individual. And while I realize that in the trial session with Mr. Dany's case, the trial attorney did not move to suppress that evidence, so it's a little bit different. But I would argue that the holding and Due should apply to Mr. Dany's case, because the case law wasn't exactly clear before Due on when an officer can and cannot record both a video and audio of an individual in a vehicle.
Attorney Spavento, is that right?
Yes, Your Honor.
So no wiretap issue was raised in the lower court, right? So this would be a substantial risk analysis?
I would argue that because of the new holding and Due, it would be the lower threshold. But even if it is a substantial miscarriage of justice, I would argue that rule did not exist beforehand. The trial attorney could not have known the rule and Due was coming. The case laws that have been before this have never really held that what an officer can and can't do recording something without a search warrant. There are a lot of cases dealing with search warrants and wiretaps with drug type issues. But I do understand that he didn't, for whatever reason, file a motion to suppress at that stage.
I think the Commonwealth argues that the so-called clairvoyance exception for waiver doesn't really apply to statutory claims. Do you disagree with that?
I was unable to find any case law that really states in essence that a statute in this essence, but I would say I would disagree with their analysis, Your Honor. The reason why is it's a fairly new law. It interprets the statute differently. And I think one of the issues that this court and potentially the SJC might take up is do they always have to get a search warrant if they don't fit within the one-party exception rule within the statute? And the statute, I think, is pretty clear in that it does have its own suppression issue within it, in the statute. I think we all agree that it was secret. It was different than in Due, that in the Due case, it was unclear how the officer was holding the phone, whether he was holding it and the defendant saw the phone. In this case, it was unclear where the phone was, whether it was in the officer's pocket or underneath the seat or something like that. The police chose not to get a search warrant. They could have attempted to get a search warrant. I think there's one factor in this because, for lack of better words, I think the police have had free rein to not to have to get a search warrant because the statute isn't exactly clear on when they have to get a search warrant.
So do we have the videos in the record that we have available to us?
I believe so.
Because I haven't looked at them. I mean, so the Commonwealth also argues that it wouldn't be even prejudicial because in addition to the video evidence, you have the eyewitness testimony of Trooper Dunderdale, you have the surveillance testimony of Trooper Davis, who were for all three transactions, you have photographic evidence of all three transactions. How prejudicial are these videotapes?
I would agree with if the way the case was presented to the jury, the evidence was overwhelming. They were able to see pretty clearly a drug transaction happening in the officer's car, but the defendant's theory of defense was a police admission to like a Bowden defense where, they made so many mistakes or so many errors, how can you believe anything they say? And if the video was taken out from the trial and the jury was not able to see it, maybe it goes to the defendant's theory a little bit more. So, there's no video here. How can you believe anything that they say?
Well, let me ask, just on the prejudice prong, is the only tainted evidence the submission of the audio-visual recordings to the jury? I have a question about Trooper Davis's corroborating testimony. Did he rely on the recording itself for his observations, or were those all independent observations of what was going on? Because he was in the van, and I believe at some point he said, that their surveillance was going on when he was in the van. So I'm trying to understand: is his testimony tainted by this error, or is it independent in your view?
I think it would also potentially be tainted in that the officer was not in. He had no way to know of what was happening in that car, but for the video, or if he was able to hear what was happening in that car. So I would say that it could be potentially tainted. I understand that one of the problems is even if the lower court excluded it, and even if this court says it should not have come in, the officer could still testify as to his observations. I understand that, but I think that goes to the weight of the evidence and helps the defendant at least a little bit in his Bowden-type defense in that.
Okay.
Any questions on that issue?
I'm sorry, I didn't quite hear that.
Any other questions on that particular?
Just to note, it's FAR is pending on that case.
Correct. I looked last night and it said deferred.
Right.
So I don't know if it's waiting for everybody else to get in on this or, but because I believe the judge who wrote at least parts of that opinion has now been promoted. So
Let's not get ahead of ourselves.
right. Unless there are any other questions, I would rest on my brief on that issue, Your Honor.
Okay. I see no questions on that
No,
topic.
that's fine.
Go ahead.
Thank you, Your Honors.
Okay. Did you want, actually, I didn't quite understand that, so you're resting on your brief completely right now?
Yes, I'm
Okay,
sorry,
fine.
yes.
So I just want to double check that no one has any additional questions about any other aspect of the case before.
Unless you want to address the issue about the negative, what you describe as the negative profile testimony. You just want to rest on your brief on that point?
Yes, I think I don't have very much more to say than I can, and less is more.
Okay.
Yeah, okay.
Thank you.
Thank you very much.
Good morning, may it please the court. Catherine Jansen on behalf of the Commonwealth. I guess I will address the Commonwealth v. Do issue. And to go to Your Honor's question about Trooper Franklin Davis and his testimony, I don't think it was totally fleshed out in the testimony to have candor with you. I do think he did testify to the fact that he saw the defendant leaving 20 Flint Street and leaving and approaching the car and getting into the car and getting out of the car. And I think that testimony, would be fairly, could be viewed as not entangled in the whole wiretap if he was surveilling what was happening inside the car and on the video of the cell phone video recording. Of course, I also don't think the testimony was fully developed as to whether it was being transmitted to officers in the van. So, but even if you were to, I think you could still consider that as corroboration of Trooper Dunderdale's testimony as a firsthand witness. I also
The audio and the video come in?
So yes, the audio, the video, the visual and audio came in. I honestly cannot remember if I moved to transmit the videos or if my brother had transmitted those exhibits. I'd be happy to do that for the court.
But your point is we need to go back and look at his evidence and see to the extent we can tell from the record which evidence is independent observation and which may have been affected by the fact that the surveillance was going into the van.
Correct, correct, because under the law, obviously somebody who watched via the surveillance, that would be also a violation of the wiretap. So that, I would concede that if he had moved to suppress, he would have been under the wiretap, he would have been entitled under due. However, I don't think there's a substantial risk of a miscarriage of justice for all the reasons that I've stated and the court addressed with my brother.
Can I just ask you on the issue about issue preservation?
Yes.
And we understand that the defense counsel, I think, did a good job throughout, didn't make a specific objection about the wiretap statute. But surely the police are aware of the wiretap statute, and are they taking that into consideration when they're making these decisions not to seek a warrant and do this? I mean, I'm trying to understand sort of how this happened and why was it presented, or were there concerns about it, notwithstanding the lack of a specific objection about this evidence?
I don't have information that's in the record. I have information from talking to the lower court ADA, so I don't know if that's totally appropriate for the court to hear. I think there was, this is part of an investigation, a larger drug investigation, along with investigation of gangs in Lynn, and I think that they potentially thought it was part of that organized crime exception statute, part of the wiretap, but I don't know if they were able to fully make that connection. So I think that might have been what was going on. I'm not totally sure why the police did what they did,
Right.
if that helps answer your question.
Yeah.
And then just, can you address the sort of the prejudice analysis or the substantial risk analysis?
Of course.
How that factors
So
in?
I think the case law was pretty developed as to wiretap and how broad the statute was. The case law through the early 2000s, even before the early 2000s, but early 2000s all the way up, going through due, there's been a lot of case law about how broad it is. I would point to Commonwealth v. Tavares, 459 Mass. 289, 2011 case, states oral communications of a defendant surreptitiously recorded by a confidential police informant violated wiretap statute. I think that would be enough to put a defense attorney on notice that even though it's oral there and didn't include the visual part, and so you might have clarified that it goes as far as that, he was on notice that at least the audio portion should have been suppressed via wiretap, or he could have moved for that. So, and there's a bunch of other cases cited in my footnote 4 of my supplemental reply brief that detail kind of more of the history. So based on that, I think he could have moved to suppress under the wiretap. I mean, the defendant did in Commonwealth v. Due, so it was out there, and so it's not preserved.
Okay, so given that you admit that the admission of this under due was error, what is your just your basic argument as to the weight of the other evidence in the case?
I think, quite frankly, the best evidence is you have a police trooper who participated in the hand-to-hand. It wasn't even that he was watching the hand-to-hand from a distance with a CI who didn't testify. He was the CI. So or not the CI, but he was the undercover officer. And so he testified about, he came in my car, he handed me this. You have his firsthand eyewitness testimony corroborated by Trooper Davis, who watched the defendant leaving his house, getting into the car, approaching the car from outside, which I don't think is wrapped up in any watching of the recording. You also have the defendant's text messages to Trooper Dunderdale, which I think the jury can more than find were, by preponderance of the evidence, were authored by him, where his own actions authenticated those text messages.
Does that mean the evidence pretty much would show that the 3 transactions happened the way that with the same price, the same quantities that were in the texts?
Yes, they did happen. The way the text messages laid them out, those drug transactions occurred as detailed. And notably, one of the drug transactions occurred on the street where the house that was linked to the defendant where the search warrant was executed. And as far as the defendant's claim that it was a Bowdoin type issue in defense, I think that really was successful to some extent about the search warrant and maybe how they executed that search warrant and what they found or didn't find there, because the defendant was acquitted of all the drug charges related to the search warrant in the house.
Yeah.
If you're done with that issue, can I ask about what's presented as the negative profiling issue? And I think maybe there wasn't any evidence of the physical characteristics of the defendant or how that matched up, but there was evidence that was presented regarding the element of the intent to distribute. And, it may be the case that the Commonwealth didn't cross the line, but it wasn't for lack of trying. I think the defense attorney did a very good job and objected very strenuously, but it did seem at times that the prosecutor wanted to get to questions that really went to the heart of the issue as opposed to sort of just offering objective evidence about the difference between distribution.
And I will say, the judge, I would point to transcript volume 2, page 55 through 57, where the prosecutor was trying to kind of get into, was this consistent with personal use or distribution? All those questions were sustained by the judge to the extent that, I think talking about the quantity of fentanyl a typical user would use and how it might be ingested, those were, one, relevant to distribution and whether or not what the defendant had in his house or on his person, what he gave to Berdundale was consistent with distribution and the composition. But also, I think those went really, again, to the drugs in the house and that's how the prosecutor argued it in his closing at volume 2, page 152 through 153, that, he didn't have all these things that were consistent with personal use. He had stuff consistent with drug use, and that was completely fair and accurate because that's part of our...
It seems fair for argument by the prosecutor. It doesn't seem fair for a police expert witness to testify to the ultimate issue, which is, I'm not saying it happened, but it seemed to be headed in that direction, but for the effective advocacy of defense counsel. And so I'm just wondering, what do you see as the line that can't be crossed when it comes to this kind of evidence?
I think, one, the line can't be crossed if this person was involved in the investigation, saying that this was drug distribution. But also, I think as far as even giving a hypothetical that mirrors the facts of the case, and saying, in your opinion, is that consistent with distribution or personal use, I think that's fine, and I think that's completely permissible under the case law. And I think that would be a fine line, and I know that was objected to and sustained, and I think, quite frankly, the prosecution wasn't hindered, but they were entitled to ask that and get that answer, and the judge, in his discretion, denied that.
So you think a hypothetical that matches the facts of the case can be admitted with a conclusion as to that, but as long as it doesn't actually go and say, well, this person...
Well, as long as it says it's consistent with, and I would point the court to Commonwealth v. Dancy, 75 Mass App Court, 175, 2009, where...
Could you say that faster?
Yeah.
I'm sorry?
Could you say that any faster?
Oh, I'm sorry.
Just going to ask you to repeat it myself.
So it's in footnote 26 of my brief, if that's helpful. And
It is helpful, thank you.
75 Mass App Court, 175. I apologize. I definitely have a problem speaking quickly, so. And there they say the use of a hypothetical question during direct examination may be admissible where they are based on evidence already admitted at trial and do not require the witness to comment on the guilt or innocence of the defendant. And there it was a very similar, it almost mirrored the question asked by the prosecutor where the objection was sustained, but based on facts that were in evidence, is this, in your opinion, consistent, with what? What would this be consistent with? And the answer, if it's drug use or drug distribution, is proper.
You said something that I hadn't really realized. So the defendant was only convicted Well, was he only convicted of the three controlled by, those three transactions?
Yes, and the cocaine found on his person during search incident to arrest.
And what was the charge, what was the conviction on the cocaine on his person? Was that a trafficking, was that a?
It was, I think it was possession. It was possession, I believe.
Yeah.
But I can check in my brief.
I mean, the packaging and the scales and stuff is more relevant to what was in the house than what, than
Correct, yep. Yeah, I think this drug expert was meaning.
Is giving drugs for money consistent with selling drugs, right? That's the.
Right. I mean, I think the expert was really more geared towards the drugs found in the house and the amount of drugs that was found there and what paraphernalia was there or was not there. And so that's what that went to. I don't think the expert maybe would have been necessary if it was just the controlled buys. So I also think that probably reduces some prejudice.
Do you want to make the argument that you make in a footnote about that the issue wasn't, the profiling issue wasn't preserved, or do you want to rest on your brief on that?
I'm happy to address the court if the court would like to hear from me.
It seems to me that that defense counsel did everything possible to preserve that issue.
Well, I would suggest I would point to Commonwealth v. Smith, 92 Mass App Court 417, 2017, Note 12. And there, that case, there was a motion in limine to preclude the use of profile testimony by a drug distribution expert. And there, the judge said, I'm going to rule on a question-by-question basis. And so there, where he, and I can't remember in Smith now if there was an objection to the questions or specific questions, or whether there was a general objection without saying what the objection was for. But here, I would suggest that something similar happened here. The complaint of testimony, specifically complained of in my brother's brief, is there were, some of them had objections, some of them didn't, but the objections were just objection and no stating the basis. The objection could have been for anything, and so you have to state an objection with specificity. However, if the court does not agree with me,
I think well,
if the court does not agree with me, I still don't think it's prejudicial error.
Objections, they made specific objections. This was very well objected to, I think, below. You may still win on the merits, but
I mean, I would just say that I think where a judge says you can object on a question-by-question basis, just saying objection without, other things happen at trial besides what you're just arguing about at sidebar that could be objectionable. So I think you have to alert the judge and allow, So, I understand the court's point, but I do, I would suggest that it wasn't preserved. But even if it were preserved for the reasons we've discussed, it's not prejudicial, amounting to prejudicial error.
Okay.
If there's no further questions, I'm happy to rest on my brief.
I think we have your point, and I see no further questions from the panel, so thank you both very much. We'll take the case under advisement. Okay, we'll move on to our second case, which is Commonwealth versus Christopher Pike, 2023-0513. Good morning.
Good morning. May it please the court, Dana Currihan for Christopher Pike. The most compelling witness establishing the defendant's guilt was the complainant's own mother. She testified that she left the defendant in March when she found out that he, quote, diddled her daughter. At the time she left him, he had been molesting her daughter for a year. That's what she testified to. And, she made things worse on cross-examination when she testified that her other daughter, the daughter she had with the defendant, he had supervised visitation with the defendant. And, the problem was she was called as a defense witness. Now, we contend that it was ineffective assistance of counsel, not only to put her on the stand, but I think more importantly, she went on the stand without really being vetted.
Well, do we know that?
Yeah. So how do we know that exactly? How do we know that's the case?
How do we know that? Because of the way she testified, because of all the things she volunteered. obviously any...
Don't we need to know more about what the conversations were, why she decided to testify, how she was prepared to testify, what defense counsel expected her to testify to in order to determine that?
I don't think we need to go that far. I don't think I mean, obviously, I think the reason she was called was there was the complainant testified that the first time the defendant gave her alcohol was on an Easter Sunday, and that they had FaceTimed while she was at work and when they opened their Easter baskets. And I guess she was supposed to say, well, no, I didn't work that day. I didn't work on Easter Sunday, the store was closed. Well, when put on the stand, she didn't remember. I mean, there was absolutely nothing helpful that she
Right, but
offered.
that you admit that could be a strategic reason for having made the decision to call her. It apparently went awry, but you know, even based on this, the absence of any kind of record supporting the ineffective assistance claim, you can guess that there was a strategic reason for doing this, which would kind of defeat the claim.
If there was a strategic reason for calling her, I mean, it was not that that was the first day. That was not even the day that he started molesting her. That was the day that he first gave her alcohol. Well, if it turned out to be another day, so what? I mean, that is, if that's all you're putting her on for, that's not much of a reason. But I think, you know, more important, if you're going to put her on, she's got to be prepared. I mean, obviously, I know that any witness can turn into Frank Pentangeli from Godfather 2. But, you know, I think you minimize the chances of doing that if you prepare your witness. You know, obviously, right out of the box when she said, you know, he diddled my daughter and he had been molesting her for more than a year, if there was a conversation beforehand, and if she wasn't just thrown up on the witness stand, I think that would have been flagged. Obviously, would not have been a good idea to call her in those circumstances. And just really everything else. The defendant was represented by 2 lawyers at the trial? Two
right?
lawyers.
And it was Attorney Condon who did the, who...
That's right, who handled that witness, and I think she really dropped the ball on this. That's the problem. I mean, we could have gone back down and filed a motion for new trial, and we would be up here in a year and a half, possibly with no better a record than we have now. But, you know, I think this is one of those rare cases when it's pretty obvious from the record that counsel dropped the ball. So, you know, that is my contention. And I know it's obviously a difficult argument to make, but I think it's there. I think it's right in the record. Had she been prepared, had they had this conversation out in the hall, and then she was put on the stand, you know, you'd know what she had to say. But obviously, I mean, that didn't happen for whatever reason. We also, this one, we contend that the prosecutor made repeated appeals to sympathy in the closing argument. There was a lot of focus on what the complainant lost. You know, she had to go to a different school, she had to live in an apartment where they didn't have a nice pool, and she couldn't go to school with her boyfriend, and all of these things as a consequence of this having happened. And I think that is, you know, the prosecutor may have been, I guess the argument now is that they were just responding to what defense counsel said, but I don't think that it comes across that way. I think it comes across as, look at all the suffering she's had, and it really goes well beyond anything that is permissible. And you know, this is defense counsel. This is the other attorney got up and said, "I object to all of it, to the whole thing."
And you don't really argue. You say you assume that preserves all of the objections. Does it really?
Well, I would,
I object to because the reason that you want specific objections is so the judge can make specific instructions.
Right.
I object to all of that. Okay, jury, ignore the entire closing argument.
it would have been better if he had said, I object to all the appeals to sympathy in the closing argument. He didn't say that, but he did at least make an effort. So, you know, whether
You don't want to include that in your ineffective assistance claim?
well, that could be. It could also be a substantial risk of a miscarriage of justice, given the repeated references to you know, her suffering.
I mean, you know, setting aside the Commonwealth's argument about this was intended to support the victim's credibility, which the defense was attacking, you know, how is just in a just general terms, discussion of what a victim may have lost as a result of the events, how is that improper appeals to sympathy? At least in a moderate amount of discussion of the impact on the victim.
Well, I mean, what the victim has suffered, what she has lost, has no relevance to whether she was actually subject to sexual abuse. It appeals to their sympathies, to the jury's sympathies, and, you know, case law from this court has said that's a real problem when in a sexual abuse case. But what relevance does it have to whether the acts took place?
So then what's your response then to the Commonwealth's argument? Well, we introduced this because, you know, the defense counsel was challenging the victim's credibility, and the point is that, well, the victim had more to lose than to gain by disclosing the abuse.
Well, I mean, I don't think the victim, by coming forward, would have understood what she was going to lose. I mean, that she was going to have to go to a different school, or that she was going to have to, you know, move out of the house. You know, I mean, I'm not sure you can make that connection. You know, and it doesn't really, you know, I mean, maybe if the prosecutor said, look, we don't want to appeal to your sympathies, but here's what I say in response to this argument. You know, that would have focused it a little bit, but it wasn't. It was just sort of general out there. Look at all the suffering that, you know, not only was she victimized by this guy, but now she's suffering even more. She's had all these adverse consequences. So I really don't buy that argument.
Okay.
Since I'm losing my voice, unless there are any further questions, I will leave the remaining points to the brief.
All set on this end? Thank you very much.
Good morning. If it may please the court, Elizabeth Mello Marvel for the Commonwealth. I would like to start with the second issue, the issue that was just being discussed in regards to the prosecutor closing. In regards to the victim's motive to lie, that was essentially the defense. As a matter of fact, the victim testified that she didn't initially disclose the abuse because she didn't, I believe the term was, didn't want to ruin the family. So she was very well aware that there could be consequences that would not be pleasant if she came forward to her mother and reported this. So the entire defense in looking at the record, because again, the record is the only thing we have to go by, there was no motion for new trial, so we have no affidavit from either counsel. So that goes to the first issue. Again, looking at the record here, the whole strategy was she's lying, she made it up, she wanted to break up the family, didn't want her mother to marry him. And you can look at the closing argument where he talks in generally about children lie, we don't know why they lie, but here we do. And you can look at transcript 3, page 49, oh, I apologize, that is the wrong site, that's in regard to issue number 1, I apologize. It is page transcript 169, where even in the opening, counsel referred to the victim testifying as what happened, highly improbable, it's ludicrous. So that was the entire defense. It's a he said, she said case, and she had a motive to lie. Now, it's very clear, there are many things a prosecutor cannot do. They cannot personally vouch for a victim's credibility. You can't come in and say, find the defendant guilty because it was so hard for this victim to come in and testify today. Those types of appeals for sympathy very clearly are improper. But that's not what we have here. We have an argument to a jury that says, don't believe this victim, she lied, because this was her motive to lie and what she was trying to do. And you have a prosecutor saying, wait a minute, did she really have a motive to lie? Look at all of the other things that happened and that she was aware of and that were consequences. And you decide as the fact finder who has the motive to lie in this situation. She did not.
So doesn't that presume that the jury would have to understand that she understood what those consequences would be in terms of school and pool, other things?
Again, where they had testimony where she said that she didn't tell because she didn't want to ruin the family, at the very least, they could infer what ruining the family meant. So whether they knew it was
In other words, you're saying it's clear that would have meant consequences personal only to her.
Potentially to her or to the entire family, because her mother and this defendant share a child. So she has a sibling.
Right, but she was the one who had to go to a different school and not have her pool and things of that nature.
Correct, but again, there was, the prosecutor also, the defense counsel talked about and showed pictures of the family, talking about, look at how, how happy they are, she's happy, they're going to these trips, they're doing all of these things. So there was a lot of talk about the family unit and what was going on there. So it's okay, it's allowed for the prosecutor to then respond to that and say, look at this and assess it for yourself whether she had the motive to lie. That is not personal vouching, and it is not an appeal to sympathy where you're saying, look at all of these things, and it's up to you to assess the credibility of the witnesses. It's up to you to ask yourself who has a motive to testify one way or the other. That's what the prosecutor said in reference to that on transcript 3, page 57. So it's the Commonwealth's position that the prosecutor did not cross the line in this particular situation, given the presentation, and that it was in response to defense counsel.
Can I ask you, you concede in your brief that counsel saying, I object to all of it, preserves the issue?
I'll be honest with the court, I had never seen it done quite that way before. It was a little bit confusing to me. I believe that the trial judge also sort of made a comment along the lines of, do you want her to repeat the entire thing? Or it seemed a little awkward, quite frankly, in reading the transcript at that section.
But you don't argue that it's a substantial risk analysis?
No, Your Honor. In regards, if there are no further questions in regards to issue 2, I would move on to issue 1. I don't know if the panel has any additional questions, but
obviously, we're troubled that there's no motion for new trial. We don't know what happened. But
correct.
That said, wasn't the decision to call the mother, doesn't that turn out to be a total disaster?
It did turn out to be a disaster. However, that's not what the assessment is. Just because it didn't go the way they anticipated or the way they had hoped doesn't mean that it wasn't reasonable. It wasn't a reasonable strategy. When you look at everything, again, we don't have an affidavit, so we don't know how often they met with her, that type of thing. We only have the record. But in looking at the record, it's clear what they anticipated. They anticipated that she was going to say she continued a relationship with him, that it was ongoing, that she discontinued the restraining order, that she left their 5-year-old with him unsupervised, that she didn't work on that particular day. So there were multiple things that they were expecting, that she was going to corroborate the defendant's anticipated testimony in regards to their ongoing relationship and unsupervised visits with the child, and not the victim, the child that they shared, the 5-year-old, and that she didn't work on that day. That's what they expected, and that's clear that that's what they expected given the way they asked the questions and their arguments to the jury, and the conversation with the judge in regards to if the mother doesn't believe her, why should you? Which again is an improper argument. The judge pointed that out. But that interaction just highlighted what the strategy was. It was to put all of that in front of the jury for them to consider that ongoing relationship that the mother had. Now, the fact that she took the stand and didn't relay all of that, from their point of view, is unfortunate, but that's not, I think that's trial practice. I think any trial attorney would tell you that, that's the nature of it, that happens from time to time, and if it hasn't happened to them yet, they probably just haven't had enough trials. That's just the nature of it. That doesn't mean it was an unreasonable strategy.
This was a very experienced defense counsel. Is there going to be if they wanted to get an affidavit from him or contact him? Doesn't he have a judicial role now?
I believe one of the two does, but Attorney Condon is still practicing. She is not. She is still practicing attorney. She is still local, and she was actually the counsel that did the direct of the witness that we're discussing here. So there really was, there was no, I don't think there was anything that prevented anyone from getting an affidavit and filing a motion for a new trial. It just simply didn't happen, which means we're left with the record. And it's the Commonwealth's position that this record reflects they had a strategy, it was reasonable. The fact that it didn't work out the way they anticipated is not a reason to find that they were ineffective. If there are no further questions, Commonwealth would rest on its brief.
Good.
Thank you.
Thank you very much. Okay. Our third criminal case for this morning is Commonwealth versus Michael Cameron, 2023-0597.
Good morning. Excuse me. May it please the court, my name is Matthew Zandrowski, and I'm here today on behalf of Michael Cameron. I think I'm going to start my argument today with my second issue, that is the booking officer's improper testimony regarding the intoxication scale that he utilized as an evaluator as part of the booking process. And so I argue that this testimony was improper because it lent an improper aura of scientific reliability to what should have been just mere lay testimony about intoxication, signs of intoxication. So the testimony at issues, page 57 to 58 of the transcripts, the DA asks him, what are your options you work with as an evaluator to determine the effects? And he answers that he can fill out the form from slightly impaired to greatly impaired. And then he eventually lands on that Mr. Cameron was greatly impaired. And so using Commonwealth v. Gerhard, which cites favorably to the Horn case, that this was improper testimony, that Mr. Cameron, or this lent a little too much.
So, so no objections, right? No, you're raising this all for the first time on appeal.
Yeah, it's a substantial risk of miscarriage of justice.
Yeah, and so, and it's a bench trial.
Yes.
Because isn't the problem with Canty type of testimony, and this, and I mean, I think it, you know, this, I think here is an interesting issue that giving this aura of science to a lay opinion is probably not the right thing to do. But the problem with that is that the jury is going to be so impressed by the scientific police officer that they're going to, you know, they're going to convict because of that. But here you've got a judge who, I imagine, there's less of a risk that a judge is going to be really impressed by a testifying police officer.
I would agree. I think the argument would be stronger if it was a jury, but I think there's some case law out there that says that judges can be swayed by improper testimony as well. But it is true that it was a bench trial.
But what's the best case on that judges can be swayed by improper testimony?
There's one New York case, I believe it's Herring, and there is another one in Massachusetts, Miranda, I think from the 80s.
Miranda?
One of my problems with this issue is that the booking officer, I think you're absolutely right that it would be improper for an arresting officer along the side of the road to sort of offer scientific-esque gradations of intoxication. That would sort of go beyond their lay, opinion capacity. But the booking officer is supposed to make gradations because he's performing a role to, presumably to determine how this person should be incarcerated, right? And that's essentially the role. You need to know how bad off they are. And I guess the problem that comes back, there was no objection to the booking officer's testimony. I mean, I could see an argument like all this is kind of irrelevant because this person is serving a different function, but there is no objection to the admission of this testimony whatsoever, which makes the issue a lot more complicated to assess. Do you agree with that, or do you agree that the booking officer testimony was appropriate to come in the first place?
I missed the last part of what you said.
Well, I guess, here's the basic question. Sort of, if you have the arresting officer's testimony and you have the subsequent booking officer's testimony, do you have a problem at all with the notion that the booking officer was allowed to testify? Because there's no objection made to that at trial.
Right, yeah, there's no objection to either testimony.
And the booking officer is serving kind of a fundamentally different role than the arresting officer is on the road.
Well, I think the testimony itself and sort of the form of testimony is still improper, where he's gone beyond, just describing what he's seen to come to a conclusion based on a form, based on some kind of rubric that just really isn't before the court, or it's not before the trial court. So we don't know kind of everything that goes into it. I think that's what sort of makes it improper. And that's what lends it an aura that it maybe we don't understand where the difference between greatly, slightly, those sorts of things, we don't understand that gradation. And so I would look at it as essentially similar or the same as an arresting officer testifying to the same sort of facts. I don't think that there would be a distinction between the two, given how it came in. With regards to prejudice, I think that there's a few things in Mr. Cameron's favor here. This applies to all my issues, but in this case, there's no evidence of any erratic operation. The only reason that he was stopped in the first place was that his headlights were off, but it was a brightly lit area. It had just been daylight savings. I think the arresting officer had testified that it might be possible that one might not notice that your headlights were off while in that area he was driving. And then additionally, a lot of the other physical effects of intoxication can sort of be explained through Mr. Cameron's medical issues, which he introduced some.
But there was an admission to drinking alcohol, correct?
There was, yes.
And there was beer found in the car.
Yes.
Some opened cans and unopened cans.
Yeah, in the trunk.
Okay. And there was testimony about the fact that he couldn't find his license and things of that nature.
Yeah, there's some level of mental confusion, but I think a lot of the physical effects are explained through medical records, through his multiple back injuries, back surgeries, explaining his stiffness, his inability to perform the field sobriety tests.
There was also a strong odor of alcohol, there was slurred speech, there was the smell of vomit and fecal matter. I mean,
yes,
there's a lot here, right?
Yeah, I think there's some on that side. I think there's just more on the side of him not being intoxicated than these cases I usually see. So we have, I think specifically the operation that wasn't erratic at all is important here. And I guess I can briefly touch on my first issue, which would be the trooper's improper testimony concerning kind of the ultimate issue of intoxication, the Canty issue. Should be page 23, 24.
Well, the ultimate issue is not intoxication, it's operating under the influence.
Yes.
I mean, they're allowed to testify about intoxication, that I think he's drunk. I think he was, what is he? He's greatly, but did he say impaired, though?
This is the arresting officer now.
Yeah, the arresting officer. Yeah, so he said he's intoxicated.
Intoxicated.
He said,
But
I believe, based on my observations, he was intoxicated.
Yes. I think though, how I'm reading it is in conjunction with the next question and the officer's answer to that next question, which sort of adopts some of the facts in that prosecutor's question.
You mean the fact that he was in the car and operating the car?
Yes.
Yeah.
And so that sort of combines to equal that he was in the car operating while intoxicated. And so I think that would be improper under Canty, as improper.
I mean, I think your argument goes to the point that Canty is tricky because these folks are always being stopped when they're in their cars, right?
Yeah.
But you're allowed to testify about the level of intoxication, you're just not allowed to say he was driving while impaired, right? And so you're saying, well, there's a strong inference that the two were connected here because of the prosecutor's question, but it does seem like more a problem of the Canty rule than what happened in this case. The officer didn't say he was intoxicated while driving. He was just asked he had been driving in juxtaposition with offering the opinion about intoxication. Right?
In the form of the question was a rather lengthy form that included a lot of these facts, but I think somewhere in the middle there. And I think the prejudicial analysis is the same as before. I think if there are no further questions, I'm happy to rest on my brief.
No further questions. Thank you very much.
Good morning. May it please
Morning.
the Court. Elizabeth Sweeney for the Commonwealth. At the outset, I think that Commonwealth v. Canty is very instructional on all three of these issues that the defendant has raised. Also, the defendant did not object to any of the issues that he raised in this brief, so the Court reviews for a substantial risk of a miscarriage of justice. And as the Court noted earlier, this was a jury-waived trial, and trial judges are presumed to know and follow the law and exclude any allegedly inappropriate testimony. I'll address the second issue, the booking officer's form where he noted that the defendant was, quote, greatly impaired. Again, this was not objected to. And in Canty, as I stated earlier, very instructional. An officer can opine to the level of intoxication. You cannot say that the intoxication offer an opinion on their ability to drive and how that impacted the defendant. That did not happen here. The booking officer testified as to his role for booking in taking intake questions with the defendant, outlining his observations. He explained that he believed that the defendant was greatly impaired, and again, that was not objected to. And even if that was inappropriate, which the Commonwealth does not concede, as I note in my brief, the judge did not rely on it when he found the defendant guilty. On transcript page 81, the judge noted that the new officer, who was the arresting officer, who had only been on the job for approximately 4 months, had to hold up the defendant. The defendant fell 3 times. He was falling to the ground. And there was no mention of this form, this booking form, or any of the testimony at booking.
Can I just address, going back, and he's saying the Commonwealth doesn't concede this is problematic. Do you see any problem here? I mean, the booking officer serves a different role, right? The booking officer probably should be determining levels of intoxication because it makes a difference as to how this person is going to be treated as an arrestee, as a detainee, right? That's important. But bringing that level, that gradation into testimony about what is essentially a binary determination here, was the person intoxicated or not, it just seems problematic. Wouldn't you agree? And I'm trying to understand why would the Commonwealth introduce the booking officer's testimony when it already had the testimony of the arresting officer to sort of establish intoxication?
I agree that with this set of facts, that it did not need to be introduced. However, I don't think that it was relied upon by the judge, and it was touched upon briefly, and there was no discussion of the booking officer's scientific training in coming to this greatly impaired statement. and again, was not objected to, and.
No,
the judge-
I get that,
Yeah.
but I guess it does seem, there seems to be something there, a concern there, and I guess I'm just trying to get your thoughts as to why do you ever have booking officers testify in these circumstances?
Typically, in a case like this, you would have the booking officer testify as to their observations, what they see the defendant doing during, they're asking him the questions, is he holding on to the desk, is he stumbling, is he, making any inappropriate statements. Here, the booking officer testified as to the odor of vomit and feces and his, the general demeanor of the defendant. And then, as we noted, this statement that he observed him being greatly impaired. But again, I don't think that it is fatal to the Commonwealth's case, where it was not objected to, and there was overwhelming evidence of guilt, and the judge, again, jury waived trial, did not rely on it in his statement. But I do agree with you that it is somewhat outside of Canty, and you're giving some sort of, like, you have these three options, and he picked greatly impaired, and why.
Right.
So I understand the court's concern, but even if that was an issue, I think that the Commonwealth is over the hurdle of no objection, and the judge did not rely on it. But it was probably better left unsaid and just the observations of the defendant. I'd also like to note that the defendant in this case, it's Commonwealth's position that there was overwhelming evidence of guilt where he was observed driving with no headlights, and it was evening. The defendant did not stop. He drove for approximately 300 yards. He pulled over perpendicular. He fell over multiple times. He had red, bloodshot, glassy eyes, and odor of alcohol, did not safely complete the field sobriety test, admitted to drinking 3 beers, closed the door in front of the open and closed beers from the back of the car, and he was observed with vomit on his shirt, and he defecated in the cruiser. And the medical records relied upon by the defendant were just introduced. There was no medical testimony as to these broken bones or broken backbones or his alleged extreme medical injuries. And again, it was a jury waived trial for the judge to weigh that testimony in light of the Commonwealth's presentation of the case. If there are no further questions, I rest on my brief.
Hold on just a second, and don't leave yet. We'll double check. Any questions? Any questions? Thank you
Thank
very
you.
much. All right. We'll hear the first civil case on our schedule for this morning, then we'll take a short morning break. So the next case is number 2023-0781, TRAN versus Jennings Road Management Corporation and others.
Good morning, Your Honors. May it please the Court, my name is Josh Davis. I represent Jennings Road Management and the other appellants in this matter. With me at counsel table is my colleague, Matt Horvitz. I begin with a couple thoughts. The first is that the standard set by the Supreme Judicial Court for joint employment in Jinks versus Credico, drawing on the First Circuit's case in Bay State, gives employees 2 routes to establish joint employment status. One is through theories of corporate disregard, either alter ego or end run. The second is through demonstration of an employment relationship between the employee and the putative joint employer. The court below conflated the 2 tests, and in conflating the 2 tests, improperly disregarded corporate form, which, as the court knows, is something that we don't treat lightly. The clearest illustration of this below is at page 10 of the Superior Court decision, which is in your addendum at page 53. There, the Superior Court writes, quote, "Plaintiff may bring a claim against an individual or entity who is not her ostensible employer if plaintiff, as the employee, can demonstrate a link between the actual employer and the separate person or entity. Key role there is the link between the employer and the separate person or entity." That's the test. Totality of the circumstances, more about that in a later. But here is the second piece. Oh, sorry, I got that just wrong. That's the link between the 2 entities. And that's
right, not
the
the
alter ego
employee.
theory.
Okay.
Here's the sentence that makes the point I just made. The basis, and this is the next one, the basis of the joint employer finding is simply that one employer, while contracting in good faith with an otherwise independent company, has retained for itself sufficient control of the terms and conditions of employment of the employees who are employed by the other employer. And that's the space where the court, we think, misapplied the law. There are 4 questions, right? The issue.
That language is from Jenks itself, right? I mean, Jenks, that's the language you just quoted, that the judge quoted, is from Jenks.
That's exactly right.
Yes.
But that's the language from Jenks that goes to the vertical relationship between putative employer and employee. The first sentence goes to the link between the entities. And as you read the lower court opinion, what the court primarily focused on was the link among the entities as opposed to the evidence that Ms. Tran was employed by Jennings Road, of which there's precisely 0.
That's not the way I read the Superior Court judge's decision. I think she did a fairly faithful application of the 4 factors in Jenks and considered other aspects too, because the 4 factors aren't determinative in themselves, but it wasn't like she was applying a new distinct test. She really did focus on the 4 factors.
So let's go through the 4 factors then and the fact findings, because our argument doesn't go beyond what she found as fact and the law in Jenks. So the first of the questions that Jenks asked the court, and totality of the circumstances is drawn from the answers to the 4 questions and then more. But the answers to the 4 questions, I think we can agree, Your Honor, are critical to the totality of the circumstances analysis. So the first is, did Jennings Road Management have the power to hire and fire Tran? The answer to that question, according to the court's findings, is clearly no. She was not hired by Jennings Road. She could not have been fired by Jennings Road. Indeed, she refers to the employee acknowledgement form, which says very clearly that she's at will and can be fired, can leave her job for any reason or for no reason, or have it terminated by the dealership, the separate corporate entity for whom she works. So that's the answer to the first question. That leans against joint employment. The second question is, did Jennings Road Management supervise and control Tran's work schedule or conditions of employment? And here the court found that no one, quote, this is the court, no one from Jennings Road Management was involved in setting the plaintiff's work schedule, close quote.
Well, that's not all she found, right? She found JRM issues an employee handbook that all dealership employees receive, right? The handbook covers vacation time, work hours, breaks, incentive programs. JRM issues a benefits guide to all the employees. It administers the 401k program. It has a human resources officers embedded in each of the dealerships who works for JRM, right? So there's a lot more than just sort of...
Right, and there's a management agreement between JRM and the individual corporate dealership by which JRM provides human resources services and other things. And we cite in the brief cases involving handbooks. Handbooks set the guidelines. That here's the law. You've got to make sure you run your business according to the law. We're here to advise you about that. But the day-to-day management of Ms. Tran, when she worked, what she did, where she did it, was set entirely by the dealership. That's the terms and conditions piece. That's the place you need for a direct relationship. Otherwise, the argument would be you could establish a direct relationship as an employer simply with paper. And it can't be that way. There has to be active management. And as to the human resources manager, Ms. Knowles is providing human resources consulting for JRM to multiple dealerships. She's not involved in discipline. Court doesn't say she is. She's not involved in hiring and firing. She's not involved in management. She helps administer the contractual obligations of JRM. Again, I think the answer, the factual findings, even the ones you're talking about, which admittedly are broader than the one I wanted to call your attention to, those factual findings are similarly consistent with a finding of no joint employment and not sufficient to get you to joint employment. Because remember...
I mean, it seems like one of your arguments is that JRM just effectively served as a third-party management consulting service provider, right? And I think this is where the Superior Court judge points out, well, they're owned and controlled by the same person. So it's not like you're hiring BDO to help you with your management function. You're the company that's doing the management, that's providing the benefits and running the management, providing the HR officer, is also controlled by the same entity that controls the dealership. So I guess that's, can you point to me a case where they rejected joint employer liability with those kinds of facts where the ultimate control is in the same person?
Well, so what I can do in the brief is point you to all of the cases that say that common ownership and control is not sufficient to establish joint employment status. I mean, this is what I mean by conflation. Those factors, common ownership and control, and the connection between the two entities, those go...
No, I agree under Sabago, that's not self-determinative, but when you consider, you're trying to distinguish JRM's function as a completely independent third-party service provider, and I think the judge is like, well, it's the same person who owns both of these companies.
Well, no, I'm not trying to say completely independent third-party service provider.
Okay.
The argument I'm trying to make, Your Honor, is that JRM was not Ms. Tran's employer, and that the Jinx question looks for a relationship between the individual employee and the putative employer, and that there is no relationship between Ms. Jinx and Ms. Tran and JRM, and that the relationships that you're focused on, and indeed that the court paid attention to, are at the corporate level, and the theories that are applicable there are alter ego or end run, and there isn't a sufficient basis in the record to find either that JRM is the alter ego of the dealership, or the dealership is the alter ego of JRM, or that any reason to think that this is an end run around Wage Act liability. So that's the second question. The third question is rate and method of payment, and here the court finds her paycheck is from the dealership. Same point. The dealership paid her. The dealership was the person to whom she worked. It's where she applied. That question, too, is answered in favor of JRM. And the last question.
Well, can we go back on that one? Wasn't there also evidence that your client actually set broadly compensation schedules and rates for all the dealerships?
Well, again, this is the difference, because remember, at least as I read Jinx, it's about the individual relationship with Ms. Tran. The testimony and the fact findings go to the idea that Jennings Road Management reviewed overall dealership performance and set overall standards. There's no testimony that says that there was anyone at JRM who had anything to say about what Ms. Tran was paid. Again, that goes to corporate interrelationship, not to Ms. Tran's individual employment situation. And the individual employment situation is the focus of the Jinx inquiry.
So, but are you contending that corporate interrelation is completely irrelevant?
No, I'm contending that there isn't a basis in this record. So I guess I should answer that question a little differently. Yes, with respect to Jinx and this individual employment situation and joint employment as an employer. There the question, and it's put pretty well by the district court in the Hamilton case, says, quote, there must be some element of an actual employment relationship between an employee and each putative joint employer. So if you're focusing on the four questions in Jinx and the question of individual employment, my argument is they fail to establish that JRM acted as Ms. Tran's employer and that the court's holding doesn't stand up. The second question is, of course, corporate interrelationship could matter. Jinx gives you two routes to find joint employment status on the basis of corporate interrelationship. One is alter ego, and there isn't a sufficient basis here for alter ego. The second is end run, which means that the corporation was created to avoid the wage laws. No evidence at all in the fact findings about that.
Well,
so my point is you could get there, but that's not this case.
But in the Jinx decision itself, it characterizes test 3 and 4 as going to the economic aspects of the relationship. And isn't it possible that a different entity has control over the economic aspects of the relationship through its relationship with the person who's writing the paycheck?
If there were fact findings that said that in this case, Ms. Tran's pay plan or the amount that she was paid was the result of a Jennings Road Management decision, of course she would have that. But there is no such fact finding here.
But the judge found that, I don't know how to pronounce her name, the JRM employee who is embedded.
Ms. Tran.
No, the JRM.
Mr. Gomes?
Nagolis?
Oh, Knowles.
Knowles, okay. She would discuss with a general manager of a particular dealership if payroll was set at higher than it should be given current profits for the overall enterprise, right? So there was some impact on salaries given this kind of role that she had in kind of discussing those things with the general manager.
That's the step that the evidence doesn't go to. In other words,
So that's you say that's a
there
erroneous
is
finding.
right. There's no evidence. There was no finding and no evidence at all that there was ever a decision made about how much Ms. Tran, or for that matter, anyone at BMW would be paid as a consequence of the review of documents that the court found happened.
I think she found there was a possibility of that kind of
But
dynamic
so I go back to the primacy of corporate separateness and this nature of it. A possibility shouldn't be sufficient to establish joint employment status. There needs to be actual evidence and an actual finding, and I think there is not one in this case.
So why is Jennings Road listed as a signatory on the compensation plan that Tran signed and the payment plan that she signed?
Well, so there are two things you could say about that. The first is that the current payment plan, the most recent one, Jennings Road is not a signatory to. The second thing you can say is that Jennings Road signed neither of those pay plans, which negates the notion that those pay plans create a direct relationship with Ms. Tran. And the third thing I could say is, I don't know, and the record doesn't tell you.
Okay. But it does seem suggestive that there was some involvement by Jennings Road, at least a contemplated involvement by Jennings Road in compensation plans, payment plans.
Your Honor, that's precisely the problem with the decision and the reason that I think it should be reversed. It's suggestive, but there isn't the fact-finding, the level of the facts that are required to come to a ruling of law that holds Jennings Road conceivably liable as the employer of Ms. Tran. There's no evidence ever of any decision by Jennings Road that had any effect on Ms. Tran. And there is insufficient evidence in the record to establish any reason to disregard corporate separateness. This case, those theories just weren't tried. And so as a consequence, on this record, on these fact findings and under this law, the case should be reversed.
Can I just ask you along those lines? I'm just trying to get full understanding of what you think's at stake here, right? There's a proposed class action, a wage act class action. The plaintiff wants to represent, I believe, all of the employees, or certain category of employees, but across all the dealerships in the Herb Chambers empire. What difference does it make whether or not JRM is determined to be a joint employer or not, as to the overall, how that entire case is going to play out?
It's the difference between claims by a number of people whose compensation was determined by a single dealership entity as to whether the Wage Act was violated, and claims by individuals, I guess, arguably similarly situated at 60 other stores whose compensation structures were similarly determined by separate corporate entities. It's a huge difference in the amount of resources and energy that both the court and the parties will invest in this case. And the point here is that this decision is insufficient to establish that Jennings Road Management is Ms. Tran's employer, let alone to go to the next step, that Jennings Road should somehow be a defendant in a class involving employees over 60 different dealerships, each of which, or many of which, are separate businesses.
Okay.
And with that...
Got one more question, if
Go
I
ahead.
may. There's a 16L letter from Attorney Simpson that says that the NLRB has adopted the proposed joint employment rule that talks about employers sharing or co-determining matters that govern employees' essential terms and conditions. What is your response to the...
My response to that is that Jinx is the law of the Commonwealth. The claim is entirely under the Massachusetts Wage Act, and that a recent regulatory change in D.C. doesn't change the law that governs review of this decision.
Okay. Thank you
Thanks
very
very much.
Good morning, members of the panel. James Simpson on behalf of the plaintiff, Ms. Tran. May it please the court. Just to jump to that quick question.
Good start.
To start, Jinx talks about there's not a lot of law on joint employment in Massachusetts, and they look to the FLSA as guidance, and they cite Rutherford, they cite a ton of cases. So the NLRB's pronouncement, I think it goes into effect February 26th, is something that this court should consider, because it does provide a framework that, at least under the FLSA, for joint employment. And they characterized the prior rule as the, quote, Trump-era rule, which was more employer-friendly. This rule is more expansive, and it specifically talks about if you're going to run something indirectly or directly through an intermediary, joint employment can be established.
It does seem tricky, though, that we have a 2021 decision pretty much on point from the SJC that we're going to, because of some recent federal developments in Washington, we're going to sort of expand the test that the SJC just established for this issue. Just seems that's an aggressive position for
I agree it's not binding on the court. I think it's more instructive. But getting back to the single premise here, Jinks talks about a four-factor test. It doesn't say that it's etched in stone. It's not a mechanical termination. JRM would want this court and the trial court just blindly apply those four factors as that's all you have to look at. But Jinks talks about totality of the circumstances. And it cites cases from other districts. The first, fourth district, it's been kind of all over the place as far as how many factors should you use. But the economic realities of the situation is you look beyond just those four factors. And if you look at even the four factors, the evidence submitted at the trial is overwhelming that JRM was and is the joint employer of Ms. Tran. Virtually every facet of an employment relationship was established. You have JRM issuing handbooks, benefits. The handbook goes through virtually all facets of their employment. It's issued by JRM Corp to all the dealerships. It says the Herb Chambers companies. On their website, we have thousands of employees. If someone wants to apply for a job, they can go through the Herb Chambers website. It's a centralized function.
So are you pointing to the first question then, by virtue of that handbook, that the answer to the question whether or not that JRM has the authority to hire and fire would be yes?
Yeah, it basically establishes all the conditions of employment. They have an HR person who's employed by JRM who works at all the dealerships. Now, in most large corporations, the president of a company is not going to fire a low-level employee. His supervisor is. And they talk about that in their brief. And yeah, her supervisor would be the one that would fire her and hire her. Herb Chambers is not going to necessarily come and hire a parts advisor. He does hire all the general managers of each of the dealerships personally. He's the president. He's the chief cook and bottle washer for everything. So they're intimately involved in the process. Ms. Noel has testified if someone has a question about an employment policy, leave, sick leave, discipline, she answers it. She's there for that purpose. In the employee handbook, if someone has a question about sexual harassment, discrimination, it points them in the direction of the officers of JRM. Those are the contact people to talk to. So everything in the handbook is applied across all the dealerships.
Right, but there's nothing in the record that supports that JRM is setting wage levels or specific wage policies in the individual dealerships, right? I mean, there's, the best evidence you have is what we were discussing with Mr. Davis, is that, well, when it comes to pay, the JRM HR employee may be speaking with the general manager about overall profit projection, things like that. But there seems to be a good deal of autonomy in the BMW dealership and the other dealerships as to who gets hired and fired, how much they get paid, what kind of tasks they're going to be doing. Wouldn't you agree with that?
I don't. I think on page 313 and 314 of Mr. Gomes' testimony in the record, I asked them questions about it, and they do monitor payroll. That's one of the jobs of the JRM. That's one of the services they provide. And they do look to see if payroll's in line, uniform across the dealerships. Yeah, they're not saying that, you have to pay Ms. Tran $15 an hour, but they are going to say you're not going to pay her $100 an hour when everyone else is making $15. So they look at that, and they have a spreadsheet for payroll. They have a dealership, profitability, and they look at that. And if things are out of whack, they're told they obviously have to change that. So Mr. Gomes did testify about that. So yes, they don't specifically say you get paid $15 an hour, but they do monitor the dealerships to make sure they're in line for profitability. And one of the things they do look at is payroll. And if they're spending too much in overtime or they're hiring people for too much money, that's going to be something that JRM looks at and is part of this single integrated enterprise.
So if Herb Chambers BMW talks to JRM and they say, you know, your payroll is running a little high, is it going to be, I mean, wouldn't they make the unilateral decision, okay, let's not pay people for time and a half on Sundays? Or are you suggesting that's a JRM-wide policy?
Well, I mean, certainly if the dealership general manager is being judged on the bottom line, and he could be fired by Mr. Chambers at any time if that dealership's not being profitable, and if one of the reasons they're not being profitable is that their payroll's out of whack. It could be, a variety of other things. It could be sales are down and whatnot. So there is a control factor there on pay. Vacation, sick time, everything that is part of someone's, work as an employee with a company is all covered by JRM through this handbook.
Do you mind just really quickly summarizing what are the specific claims that your client has under the Wage Act?
Specifically, there was following the Sleepy's case in the SJC about Sunday pay, and this essentially what was happening in some of the industries, in car dealership industries, they were saying they weren't paying them overtime. And they were saying because we gave them commission enough to satisfy that overtime, that was enough. And Sleepy says, no, you can't use commissions as an offset against overtime. So that's essentially what the case is. And further to your question about, the difference of what this really means is, I think counsel was correct. It'd be a single individual dealership claim as opposed to if she is considered to be an employee of JRM Corp, then it would be a larger case.
And I guess just to follow up on my colleague's question, but sort of, and I know you haven't had a chance to do merits discovery or anything like that. You've just had this proceeding on the joint employer issue, but the Wage Act practices that you're challenging, are those things that you ultimately hope to link to JRM, or is just you're bringing in JRM for strict liability, and then if you're able to proceed with your claims and establish them, JRM is on the hook through strict liability. Is that the
yeah, if JRM is determined to be the employer of Ms. Tran, then my argument would be that she, on herself and on behalf of other similarly situated individuals, could bring the claim on a class basis. It's been done before. There's been tons of cases when that Sleepy's decision happened that a lot of claims were brought against car dealerships and other entities, and they were brought on a class basis and eventually resolved, however. But yes, that would be a liability just like any employer under the Wage Act. So that was essentially what the case would be.
Let me ask you, how do you respond to Mr. Davis's argument that, so the judge found basically all four factors under the Jinx test go in favor of JRM, but so she got to the result by applying the corporate, the piercing the corporate veil type of arguments instead?
I don't think she went that way. I think she looked at the totality of the circumstances. And I think under Jinx, that's what you really look at. It's not just those four factors. You have to look at the total arrangement between JRM and the dealership in Ms. Tran. And she did cite the fact that, there's common ownership, there's common, the handbooks, the benefits are all the same. There's a 401k policy that's sponsored and administered by JRM Corp. So above and beyond those, strictly four questions, there was enough evidence of joint employment. And Jinx also talks about this end-run alter ego as another basis. And in this situation, I think Mr. Chambers is well off that this is not going to happen to his companies. But you could have a situation where a company does this exact same arrangement, and all these people who are employed by these subsidiaries don't get paid properly, or that subsidiary goes out of business. And now they're left, who do they go to? Well, if there's a company that's basically run by the same people, owned by the same people, and they're just using this as a way to kind of avoid liability of the Wage Act, I think that's what Jinx talks about. And I think under this structure, that would be something that the court would consider as an alternative to these, if you're going to go by those four strict tests. But I don't think you need to even get that far. I think there was overwhelming evidence that employment was established based on the arrangement that was set up. There's a flow of money from the dealerships on a monthly basis to JRM Corp. in exchange for all these employment and other services. And having HR people who are employed by JRM, and as Your Honor pointed out, some of the documents that were turned over had JRM's name on it. Now, the fact that they didn't sign it, I think is not of any consequence. They generated this document. So they're sending out policies and procedures, counting gun policies with Herb Chambers Company, JRM Corp., listed on these documents. They have a central, app that for all employees. So everything employment related is coming through JRM to the dealership. It's uniform amongst the dealerships. So I believe the judge had more than just those 4 factors. I believe that her analysis was sound based on Jinx. And as I indicated at the beginning, although not binding on this court, the trend under the FLSA, which Jinx does talk about, they're going to look at, is to be more expansive on a joint employment analysis. With that, if there's no other questions, I will rest on my brief. Thank you.
And if you give me a moment, I'll check. No questions? I see no further questions. Thank you
Thank you,
both
Ross.
very much. We'll take the case under advisement. All right, we'll take a short morning recess now.
All rise. is reopened. Please be seated.
Thank you all. All right, so we have two cases left. The next case I'm going to call is partially impounded is 2023-0603, DC versus AC. Still morning. Good morning.
Good morning, Justices, and may it please the Court. My name is Amalia Jorns. I'm here from Northeast Legal Aid. Sitting with me is my colleague, Rachel Biscardi, and in the gallery is Catherine Combs, who is also on the brief.
Okay. I'm just going to ask you to move a little bit closer to the microphone or pull the microphone a little bit closer to you. That'll probably do it. Thank you.
This Court has long recognized that the purpose of an abuse prevention order under Chapter 209A, Section 3, is to protect survivors of domestic violence. We are here today because the district court decision in this case infringes on that protective purpose. The district court's mandate by statute is to address safety concerns relative to the person who has suffered abuse, and by extension, to that person's children. Perpetrators of abuse can use the court system itself to perpetuate the cycle of domestic violence when district courts allow defendants to modify abuse prevention orders without meeting any burden at law, and then shift that burden to the plaintiff. Here, the district court modified an abuse prevention order on defendant's motion for modification to allow contact between the defendant and the plaintiff's children less than 3 months after that order was first put in place. And its rationale, as it's stated on the record, was its own philosophy on parenting time. To quote, "I'm allowing this because I think that the children need both parents in their lives and to have some communication for closure or to understand something, and the kids are not at the age where I would find it inappropriate to have contact." It is
Attorney Jones, I'm sorry to interrupt, and I hate to burst the bubble. And I appreciate what Northeast Legal Aid does, and I appreciate all of the attorneys for coming here. But in the brief, you mentioned that there was a divorce action taken in this case.
That is correct.
And we can take judicial notice of the proceedings in the parallel proceeding. And in January, I think, or maybe last December, a contact order issued out of the divorce case.
That is correct, Your Honor.
So doesn't that supersede the 209A?
That would supersede the 209A with respect to text contact. However, our position is that does not remedy the harm that was caused by this district court order allowing text contact
So
with the children.
what could we as a practical matter do here?
What we're asking the court to do is to vacate this decision. This order is still in effect. The abuse prevention order is still in effect. It's going to be subject to a renewal in March 2024. And every judge...
The child contact provisions are superseded by the divorce case.
However, when this comes up for extension, the courthouse in which this takes place is a large courthouse. Almost every judge you see on an extension or a modification is different. Those judges are going to look at this order, and if it is not vacated with respect to text contact, they are going to be under the false impression that this order was entered on the proper legal standard and make decisions about what happens with respect to the plaintiff and the children in this case. In the worst case scenario, they will look at that continuing contact or that contact provision as it was ordered and say, okay, in this case, clearly contact was not a risk. Maybe there is no continuing need for this order. I would also point out that in Moreno, this is a case that has important, as in Moreno, this is a case that has important public policy implications. What happened here is the district court did not hold the defendant to his standard of clear and convincing evidence by a substantial change in circumstances that there was no longer a need for the protective purpose of this order, in this case, the contact with the children. And as I said at the outset, this is an issue that bears repetition. This is an issue that comes up all the time where defendants use the modification process in the district court as a way to harass and to continue the cycle of abuse against plaintiffs. it's only the probate in the family court that has the authority and experience to address the question of how to best maintain safety protections for the plaintiff and children while crafting a plan of visitation or other forms of contact consistent with the children's best interests. Your Honors, I would point out that in this divorce case, the defendant did not bring any sort of motion for parenting time for 7 months. The divorce case was filed in December. It was served in January. Over the course of 7 months, he did not bring any sort of motion for parenting time. At the same time, in addition to the 3 motions for modification that are listed in the record, he brought 2 additional motions for modification in the district court over the summer in July and August. All 5 of those motions for modification were related to child issues. In fact, in June, he filed both in the probate court and in the district court on the same day, seeking essentially the same relief. At the first hearing before the probate and family court, which took place in August of 2023, after that hearing, the court ordered exactly the kind of remedies that we would want to ask from a probate and a family court that are not available to a district court. The court ordered that all visits take place in a supervised visitation center and be supervised by a professional. The court ordered that the one child who was already in counseling continue in counseling, and that the other child be put in counseling. When this came up for a status hearing in December, which is, just as Manning, you pointed out, was when the no text contact had come into place, or the text contact had come into place, the court continued the supervised visitation, continued to order that the kids go to counseling, and in fact rolled back what had happened in terms of contact. In June, the defendant had been successful on a modification again, this time because he claimed to the district court that mother had started to block the children from having text contact and that he wasn't able to reach them. So that court turned around, looked at the previous order and said, okay, there's no text contact. There's text contact. If you can't reach the children this way, they should have a way to reach the children, and ordered social media contact through Snapchat and through, I believe it was Facebook. In December, when this came up in front of the judge, that was actually rolled back to only text contact and no video contact except for a call on Christmas. And the reasoning was because the defendant in this case, and I appreciate that this is outside the record, had been consistently using social media to contact these children to talk about the circumstances of the litigation.
So if you go back when the order expires, is there any possibility that the district court can try to unravel the probate court's order?
There is no possibility that the district court can issue an order unless there are new circumstances. So if, for example, there was an emergency that came up in the next 2 months, if the defendant for once again violated the order, and there were circumstances that again went to the issue of safety, and we could not get into the probate and family court fast enough to address that safety issue. In that circumstance, yes, the district court could issue an order that would temporarily supersede the probate and family court. However, with respect to the text contact, you're absolutely right. No, that is the order of the probate and family court. However, as I've pointed out, these judges look at these previous orders and think, well, if there was text contact here, if there was social media contact here, it must have been okay then. What has changed?
If we were to issue a Rule 23 decision on this case, would that have the effect that you want, or do we have to issue a published decision in this case to really have the effect that you want us to have?
And we are asking for a published decision in this case. I think when we actually look at what the court was looking at here, this decision was based on a judicial philosophy about parenting time. We would submit that parenting time is not the question that is before the district court, and in fact they're not statutorily authorized to look at parenting time in these cases. And when the district court exceeds its authority based on its own view of what is important for children to have text contact with their parents, it supersedes, it essentially is an end run around the probate and family court.
How much of a burden does the defendant in this case have to establish a significant change of circumstances to warrant a change in the contact? What's your understanding of sort of what does he have to establish?
My understanding is that it is a heightened burden, and that burden has been adopted by the courts to reflect the important safety considerations that are in place under Chapter 209A. Clear and convincing evidence is more than preponderance. It is, as we said in our brief, a burden that is not without teeth. In terms of what the defendant would need to establish to show a substantial change in circumstances. And in this case, it was a substantial change in circumstances that would show that contact with the children would not harm plaintiff or the children. The things that we've seen in some of the case law are examples like where a defendant has made a change to move beyond the domestic violence or the abusive behavior that caused the safety consideration in the first place. So if, for example, if a defendant were to come in and say, I've undergone a course of, if they were using substances, I've been in treatment, I'm in rehab, I've been sober for 3 months, all of these incidents happened when I was under the influence, I've moved on, in that way. Or if the person had completed an intimate partner abuse prevention program, which is an extensive 52-week program, or had at least started that program, to show some acknowledgement of how this behavior had impacted the plaintiff and the children.
And that's helpful because it's a little bit of a, how do you prove the negative? And here clearly is just saying I'm a good dude is not going to be enough. But so you're saying there has to be some kind of affirmative course of action taken by the defendant to justify, under clear and convincing evidence, the kind of change.
To reduce the harm. I think that there is another set of circumstances that you could also look at where there's just very much a practical consideration. So for example, if the defendant gets a job that is, unavoidably close to the children's school or something like that. Perhaps in that case, that would be grounds for a modification, and other provisions could be put in place, can show up at 8 o'clock for the job, leave at 5 o'clock. That will not be a violation of the order, and that would give the police the information that if the defendant is at the school, at a time that's not in that, that's the sort of order that I think you would be looking for on a modification. So to return, I wanted to talk first, and this goes to the significant change in circumstances, is, what did the defendant show here? What burden of proof did the plaintiff, did the court hold the plaintiff, or the defendant to? And here, we only had really 3 things that the defendant stated on the record were his reasons for why there had been a substantial change in circumstance. The first, Your Honors, was that he said, I'm a good dude. Defendant's own opinion of his personality, I would submit, is not the basis upon which to modify the protective provisions of an abuse prevention order. The second is that he said he's not with mom anymore. Justices, I would say that this is a feature, not a bug, of an abuse prevention order. The expectation is that an abuse prevention order will keep away the perpetrator from the person who has experienced the harm and where it's justified by independent support, their children. And finally, he talked about his desire to participate in upcoming events with the children, like Christmas and children's birthdays. When this no contact provision was put in place in September, it was added the children, and that was at a full evidentiary hearing at which both the defendant and the plaintiff participated. And at that hearing, which was on the same day the defendant was arraigned on a series of criminal charges related to his attack on the plaintiff, no contact was ordered. So his desire to participate at Christmas was certainly something that was in the contemplation of the court when it extended this order with no contact until the next extension date in March. If anything, if we look at what had happened since September in this case, and this was all shown to the district court, admitted to by the defendant, included in the plaintiff's affidavit, if anything, and there was a police report submitted as well, if anything, they showed an increased risk to the defendant in this case, or the plaintiff in this case. The defendant sent a message to his family the day after he had been arrested and this order was entered. He parked right outside the plaintiff's and children's home. He sent his son over to retrieve belongings, and he parked outside the older child's bus stop, making that child very uncomfortable. I think it's clear also—
Can I ask, is sending the son to retrieve the belongings, is actually a violation of the of the order?
It's not a direct violation of the order. However, there was no permission. He's essentially initiating contact. If you use contact through a third party to get to your victim, that can be construed, depending on the circumstances, as a violation. There has to be a direct chain of events that leads to that, but you can't use someone else as your proxy to continue to harass.
So here it would be a violation, that act would be a violation of the order.
It's definitely a close call, I think, based on what the police department and the DA's office, but I do think that depending on the circumstances, this could be considered a violation, especially if the son was to show up and say, you know, I'm here from
But I
my
guess
dad.
he's not being prosecuted for that in any event.
No, he's not being prosecuted from that, but he is certainly being prosecuted and has in fact, has a quaff in place until September 2024 for his original violation. Just to summarize, what we're asking for, what we're saying here is that the harm is clear. The defendant brought 5 separate motions to modify this abuse prevention order in 8 months. Every one of those judges, including the judge on this modification, told him to go to the probate and family court. This is a textbook example of a defendant using the modification process to further abuse of the plaintiff. Thank you, Your Honors.
No further questions. Thank you very much. We'll take the case under advisement. All right, we have one more case on our list today, and that's case number 2023-0743, Basani versus, I'm going to say Cilant is the name of the corporation here. I'll expect you to correct me when you start your argument.
May it please the court. My name is Colin Hagan on behalf of Cilant, Inc.
Say it again, please.
Cilant?
Cilant, thank you.
Yes, Your Honor. What I want to focus on in my presentation this morning is that one of the things that is, I think, a guiding principle of how to look at whether a particular stockholder is a controlling stockholder, especially with regard to a particular transaction, which is what Cilant alleges here, is that there's no particular framework. There's no specific set of criteria that the court has to consider or that a plaintiff or counterclaim plaintiff in this case has to allege to establish that control. Now, there are certainly examples, and the courts have looked at these examples, and they're the typical types of examples that may cut across various cases, but there's not a specific fact pattern, there's not a specific set of principles or factors that one must show.
But it does seem well established in the case law that mere exercise of your contractual rights is not enough to establish decision control, right? So you have to have something more, right? And I guess my question to you is, what more did you plausibly allege?
Sure. Well, first of all, Your Honor, I think that's right, that the case law does generally recognize that just exercise of a contractual right alone is not sufficient, but I'll get to it in a minute that in the Voight case, the court did describe that in a particular set of circumstances similar to what we've alleged here, that exercise of a blocking right, especially combined with an effort to starve the corporation of capital, is a highly effective use of control. So to get to the second, or to get to your question, Your Honor.
Well, when you do get to that, you might want to talk about how there was other factors also at play in Voight that were there and don't exist here.
Understood, Your Honor, and I'll be sure to touch on that. So Cilant has alleged basically 5 factors, one of which is the blocking right. The first factor that we've alleged is that the Basanis held 28% of the company's voting stock. Now, in the Basho case, the court described that by statute, Delaware law specifies that a person holding 20% is presumed to have control unless there's proof by a preponderance of the evidence to the contrary. So that's in Basho.
Presumed to have control with 20% of preferred stock?
8 Delaware Code, Section 203C4.
I thought the parties agreed that they did not have actual control.
I had the same impression, that there was not really an issue whether or not that there was actual control based on the percentage of the ownership.
Not actual control over the entire corporation, but it's a factor, and it's something that Cilant has alleged, and it's something that, again, Delaware by statute.
Well, it's a fact. What was it, 28%? Let me look.
28%, yes, Your Honor. And in Voight, the controller held 38%. So a minority, because, and the reason I raise this is because the Basani say, well, we're just minority shareholders. We can't possibly have control. We can't possibly control anything. But the Delaware courts and Delaware by statute says, yes, a minority shareholder can exert control.
I think we should probably concentrate more on the facts that you say, that you allege are sufficient to show control over a specific transaction.
Absolutely.
Okay.
So that is one of them. The second, of course, is the blocking right. And what I want to point out about the blocking right is that in Voight, the court has says using that blocking right, it's a highly effective form of control when you can use that to channel the corporation into a particular course of action or presumably away from a particular.
I understand it. The contractual right that the founder, that the Basanis have, is to prevent dilution of their 28% of preferred stock Series 1. And the board's finance idea is, let's give Arrowroot more and dilute Basani.
That's not quite right. The right that we're calling the veto right or the blocking right, it essentially was a provision that says if the company wants to grant more equity or issue more shares, it needs the founder's approval in order to do that.
Right, because you're diminishing their position.
Exactly. Well, that's,
don't they have a right to exercise that? I mean, so you're saying they have this blocking right, but to protect them, but yet they have to exercise fiduciary duty and consider everybody else and give up their right?
Well, I think, and that gets to exactly how and why they're exercising that right. And because they were doing that, and what we've alleged is that they were doing that in a aggressive effort to try to starve the company of capital in order, and we've specifically alleged that they threatened to block any form of capital raise, to block anything that would allow the company to have the lifeline that it needs to operate in order to run the company out of business so that they could either reacquire it or seek some liquidity. We've specifically alleged that in the counterclaim. And so with respect to Voight says that when you have the right to do that, and it uses, Voight describes this as the paradigmatic example of a abuse of this type of blocking right. And it says when you have a cash-burning, asset-light company, which we would submit is like Cilant was at the time, the ability to choke off the air supply is a strong indicator of control, particularly if there are factual allegations that the party holding the veto right used it to force the company into a vulnerable position. So and to get to Your Honor's question, in Voight, the blocking right wasn't a strong factor in that case because all the claim there was just that there existed a blocking right, but there was no allegation that that blocking right was actually used. But nevertheless, the court says, yes, using this blocking right can be a very effective form of control. And notably, the court said it's unlikely that the mere use of a blocking right would be enough. It didn't say never could be enough, didn't say that is categorically insufficient, but it did say it's unlikely.
Can I just get back to the basic question that my colleague raised, is sort of, can you ever have, as a minority shareholder, a fiduciary duty to support an action that's going to dilute your ownership in the company? I mean, you're talking about blocking rights and things like that and motives and things like that, but it sort of seems so fundamental that you should be allowed to oppose an effort that's going to make you poorer. And I am trying to get around that problem here. Like, is that your position, that the fiduciary duty that you're claiming overrides your self-interest in protecting your ownership in the company?
Well, in a way, that's what fiduciary's duties do. So when a director has fiduciary duties, they are definitely supposed to override your self-interest in the company, whether you're a shareholder or not. And so that same principle of fiduciary duties, if it arises through your control as a shareholder, I don't see why that aspect or that principle of the application of fiduciary duties would somehow not apply.
Well, isn't this a little bit different, though, when you have a minority shareholder who actually, as a result of taking a move, removing themselves from the board, and at arm's length, I presume, because there's nothing that says to the contrary, negotiated these contractual rights That's a little bit different than just somebody who comes in on the board as a director or whatever and is, and automatically has a fiduciary duty to the corporation.
Fair. Yes, Your Honor. And it's not just these rights that we're saying impose the fiduciary duty, because, and we'll get to these other things, but the other one thing to take into account is that the Basanis, by their own words, describe these rights as controls. They don't say these are our minority, I mean, they call them protections also, but they say they're enhanced controls. And so I think, by virtue of their own subjective description of these rights, that has to be taken into account. They view them as levers of control. And that is also something that should be taken into account, again, because the courts in Delaware describe that you're looking at a confluence of circumstances. You're
Aren't we
looking
just
at a
looking at
nexus
what
of
you've
facts.
pled in your counterclaim? Aren't we limited to looking at what facts you're relying on in the counterclaim, let alone the amended counterclaim, to determine whether or not this case, it should have been properly dismissed?
Yes, Your Honor, and I believe we did allege in the original counterclaim and the proposed amended counterclaim that they were talking about these as controls, but they've also described that in their own complaint, and their own first amended complaint. And so it's not like we're asking the court, I understand this was not a motion for judgment on the pleadings and it was a motion to dismiss, but it's, it's within the scope of, I think, what the court can consider. So the other aspect here is just an overall plan of harassment. And there are courts, for example, the Info Group case that we have cited on our reply, and the Basho case has talked about this, whether it's what we've alleged are things like threatening the board with lawsuits, accusing them of breaches of fiduciary duties, accusing them of grossly mismanaging the company, making stop and start serial books and records demands, obstructing the operations of the company. We've alleged they were controlling loyal employees of the company, including employees that had access to the bank accounts, and that they controlled a loyal employee of theirs to basically extract money from the company's bank account. That's another element of control, and that also fits with the idea that they're trying to starve the company of capital. We've also alleged that they were...
Is that one of the things that was part of that package of late discovered materials, what you just said about the...
No, Your Honor, that was something different. This was something that we had known about and that was pleaded in the original complaint and also in the proposed amended, a counterclaim. And you would find that at page 147 of the appendix. And that they specifically threatened to another employee that, don't believe what the management tells you, because this company's going underground, because we're going to block anything that they try to do, no matter what it is. That's at page 148 of the appendix. And the Info Group court said that, when you were making these types of threats, when you're accusing the management of fraud and things like that, that one may reasonably infer that these allegations that the stockholder used to sought to intimidate the board defendants, and in doing so dominate them. That's exactly what we described here.
Can you respond to the Superior Court judge's ultimate analysis, which is that nothing that the Basanis wanted to do, they weren't successful in that, right? And I think his analysis that, they wanted to first require the board to share information. The board said no, right? So they weren't successful at that. And then they wanted the board to repurchase their shares, and the board said no. And so if you have to establish that they actually exercise control over a particular decision, the Superior Court judge's analysis, well, they tried, but they weren't able to do it. So it's not just the prospect of exercising control, you have to actually exercise control over a decision. So how do you respond to that analysis?
Understood. And so first of all, we say that they did exercise control over the proposed course of action that Cilant wanted to take, the extension of the Series 1, by the veto, but also by all of this harassment, because that dissuaded from the board from acting because of all these threats. So that's one thing that they achieved, and that's a specific transaction for a specific dollar amount that was identified that they achieved. The other thing that they
You're saying
achieved...
that they defeated the board's attempt to raise capital
in a specific
by
transaction.
issuing stock.
So that's one thing. And to get to Your Honor's question, the other thing that they
even
did...
without the harassment.
I'm sorry?
Even without the harassment, though, without the the plaintiff's consent, the board couldn't have acted anyway, right?
Could not have done that without the plaintiff's consent. Yes, Your Honor. And so the other thing that they did was, again, this starvation of capital and this just this harassment, because what they were trying to do, which they didn't achieve, is to, well, it's debatable whether they achieved it or not, was to run the company out of business. I would submit that they didn't do that, but that's what they were trying to do, run the company out of business or get bought out. Correct. They did not achieve either of those things. But in Klein versus Wasserman, the Delaware Chancery Court said that theoretically, actions implementing aspects of a larger strategy could themselves support the particular outcomes to support a theory of decision-specific control. And that the Chancery Court has left the door open to, even if you don't fully succeed in your aim, if you're doing things along the way to try to achieve that, then that could give rise to the control that therefore gives rise to the fiduciary duties.
The judge relied on Klein for his analysis, right? So in that case, the Breslows, as pled, their sole goal was to monetize their individual investment as soon as possible and attain a buyout of their interests. Indisputably, the Breslows never achieved that outcome. And he says, well, that's exactly what happened here, right?
Well, they didn't achieve that outcome, but again, that court left open the idea that if you're doing things along the way, and what that court analyzed was that what exactly did they do along the way that was getting them towards trying to achieve that outcome? Here, I submit that we have alleged some of those additional things with the harassment, with the starvation of capital, and the other factors that I've described. So
Yeah, I do have a question. You started out by saying there's really no test, there's no framework, there's no criteria, there's a bunch of cases. And I have a question about what is the precedential value of a decision of a single chancellor of the Chancery Court? Is it like, is it like the business litigation session here? Because there seems like the decisions do go all over the place.
So that's right. That's how I would view it. As much like the BLS, the Delaware Court of Chancery, I guess is highly regarded for its decisions, and there are numerous decisions that we've submitted. I don't understand I'm running over, but like the Voight case, like Vuono, and there's some consistency in them. I'm not aware of a Delaware Supreme Court case that addresses that.
Okay. For the questions, thank you.
No, thank you.
Thank you very much.
Good morning. Thank you, Your Honors, and may it please the Court. With all due respect to my brother and friend, Mr. Hagan, as well as this Court, Sigilant's claim here is really the height of absurdity. As Justice Massing asked, they can block additional equity through their contractual right. So are we trying to hold them responsible for the subsequent transaction which did dilute them? I mean, that's what we're talking about. Sigilant alleges they used their contractual right to block equity, so we were forced to issue debt at 18% to our controlling shareholder, something which was the subject of the Basani's affirmative claim against the company, which we have brought in Delaware and are going to trial on next month. So the idea that they controlled the company in order to engage in a transaction that harmed them is absurd. To Justice Toone's point, as the Court pointed out, we didn't achieve control, or we would have gotten bought out, or we would have achieved our goals. And in fact, the Klein v. Wasserman case says exactly that and is very similar. There, the Court starts out by saying these minority shareholders, this was a case of buyer's remorse. They became minority shareholders, they didn't like it, so they did all sorts of things to try to get bought out. They threw their weight around, demanded information, threatened to sue, got someone fired, but in the end, they weren't able to actually get bought out because they didn't control, and therefore they weren't controlling shareholders.
I take that point, but back to Justice Massing's point that the precedent seems a little bit all over the place. There is a reference, I don't know what case it is, but they talk about actual control can be evidenced by use of contractual rights to induce or coerce the board of directors to approve or to refrain from approving certain actions, right? So the argument is here they wanted to get this additional equity investment from Arrowroot, and your clients stopped that from happening, right? So I guess, is it just a matter of them not achieving their affirmative goals, or does the fact that they're exercising their contractual rights to stop something that the company wants to do, can that be cognizable in this kind of context?
It can't. And I would submit, and I've read these cases a lot, I would submit that when you read them all, they're not necessarily all over the place. While they don't list a factor test, there is real consistency that runs through them. And addressing the point about the contractual right, the Thermopylae Capital Partners case, which both sides cite, again, motion to dismiss was granted. In that case, the minority was found not to be a controller, and they exercised their contractual right. And the court said, under Delaware law, however, contractual rights held by a non-majority stockholder do not equate to control, even where the contractual rights allegedly are exercised by the minority stockholder to further its own goals. So the blocking of the equity in and of itself cannot be the transaction that serves to establish control, because that was blocked by a contractual right. Yes, there are cases where a minority shareholder uses their blocking rights, but there are also additional indicia of control that they use to then achieve a successful transaction. And that's the case in Boyd is precisely there. While they had blocking rights, they also controlled 4 of the 12 board seats. They controlled directly. They controlled 4 more on top of that through contractual relationships, and they were able to control the board to enter into a merger that benefited them.
So your understanding is that the some other thing you need to have in addition to exercising your contractual rights has to be some other kind of control-based thing, because your colleague says, well, there was harassment, there was angry letters, there was, communications with employees, there was all these other kind of things, and your position is none of that gets you where you need to be in terms of establishing a claim.
That's right, because it didn't, now if the Basanis had blocked the equity and they had used other means to control the board into forcing the board to buy them out, we'd be in a different place. But that didn't happen, and so it's not a question of inartful pleading. It didn't happen, so it can't be pled.
In Attorney Hagan's reply brief, he cites a couple of cases, Zong Pin and Sisiv, where 2 different chancellors seem to say that if a minority shareholder who could control the company, it doesn't have to be successful, that they could control. How would you distinguish those cases? Can you?
Yes, I would, I think they're distinguishable upon first reading. And I'm just looking at my notes here, there's about 15
I don't
cases
expect
that
you to have memorized all of the chancellor's decisions.
So in incisive, the person who was the defendant was the chairman of the board. He was hands-on in operations of the company on a day-to-day basis. He owned a large enough block, and I think this is important. The Basanis owned 28%, and as long as you're not above 50%, obviously you're not a controller by the amount you own. But the relative ownership is important. You can be a 30% owner, minority, but if you are the largest owner of stock, you can throw your weight around in a different way. Basanis owned 28%, and Arrowroot owned nearly the rest. Yeah. So nothing could happen without Arrowroot deciding to do it. So in that decisive case, the defendant was a 46% owner and the largest shareholder in the company, and he was able to complete a transaction that was being challenged in the case for his benefit. In the Zongpin case, again, there was a merger that the defendant had allegedly forced the company into that benefited the defendant. In that case, Zhu was the minority shareholder. He was the chairman of the board, the CEO, and held the largest block of stock, and again was able to force the company into this merger that benefited him. Here, Cilant is apparently alleging that the Basanis forced Cilant to dilute them, which we have sued Cilant for and are going to trial next month in Delaware on. So it really is, again, with all due respect, I don't want to be flippant, but it is absurd that this transaction that they didn't want to happen, that has harmed them, that they're suing over, is the basis of a claim against them because they supposedly exercised contractual rights, 3 moves before that.
So do they have to? I mean, on their without prejudice or with prejudice claim. So you withdrew your claim here so you could bring it in Delaware. So do they sort of have to fight with their hands tied behind their back now because of the res judicata effect of this one?
Well, I would say if they tried to bring they have not brought a counterclaim for breach of fiduciary duty in Delaware. So that
And
claim,
they can't.
well,
Not right now.
they can't because of, I would argue because of this decision. I would frankly welcome it because I have no doubt that it would be squashed whether there's res judicata or not. They haven't brought that claim.
I guess it's fair. You don't want to have to relitigate what you just litigated here in Delaware. Yeah.
I wouldn't mind, to be honest with you, I wouldn't mind relitigating this issue in front of the Delaware court. I have a feeling that there's a reason why it wasn't brought down there. Because, I mean, one of these decisions is listed by we've cited, was written by the Vice Chancellor we're in front of. They deal with these issues all the time, and this is...
Would you agree they're like business litigation session, but maybe on steroids?
Yes, they're a trial court in that way, and they must follow the Delaware Supreme Court for sure. But they write 100-page decisions routinely, and not all these issues end up going up to the Delaware Supreme Court. So typically, you're citing these Chancery Court decisions. I don't know if Your Honors have any other questions. I'd be happy to answer them.
There's no. When I took your brief out and it says from Arrowwood LLP, I'm like, wait a second, isn't that the other owner? That's Arrowroot, right? There's no relationship.
It's caused some interesting typos.
Okay. So I take it, just to be sure, that anything pending in this case is not going to be affecting the litigation the trial you're starting next month, currently?
That's right, Your Honor.
Okay.
I think, again, some of these, I will say, this conduct that they have alleged I assume they're going to try to bring it out of trial to, as a matter of evidence to demonstrate unclean hands or, biased motivation, but there are no claims against the Basanis in that Delaware case for breach of fiduciary duty.
Okay.
Thank you very much.
For the question. Thank you both very much. We'll take the case under advisement, and we are finished for the day this morning.
All rise.